Have you ever received an unexpected parking charge notice through the door and wondered what it's all about? I want to help you understand the notice to keeper and tackle this confusing bill. A notice to keeper is a parking charge from a private parking firm. It's distinct from an official penalty charge notice, or PCN, that comes from local authorities. If you've been found parking unlawfully in a private zone, companies can pull your details from the Driver, Vehicle and Licensing Authority, or DVLA for short as we know it. Thanks to the Protection of Freedoms Act, the registered keeper of a vehicle can be approached and might be liable for the parking charge. While the UK law clearly outlines the definition of a parked car, this is exclusive to public parking. Private firms, on the other hand, have the autonomy to set their own parking regulations, and some common reasons you might receive a notice to keeper include parking in a disabled spot without the required sticker, overstaying in a private car park, misusing facilities like supermarket car parks, incorrect parking like not parking within the white lines. A typical notice to keeper should have the following details: vehicle license number and other specifics like your make and colour of your car, details about the parking offence location and time, charge information and potential repercussions for non-payment, company details and instructions to challenge the fee. Now, when such a notice lands on your desk or through your door, then you essentially have three choices. You can settle the parking charge, identify the driver if it wasn't you. You can challenge the parking charge, ignoring this fine isn't wise. As a keeper, you might be held accountable. If someone else was driving, notify the firm and share the driver's details. If it was you, either pay or challenge it. Note that this is just an invoice, it's not legally binding, which means you do have a bit of room to negotiate. Private parking companies often employ aggressive tactics to ensure payment. However, it costs them money to take you to court. This gives you a bit of leverage. Reach out, attempt to overturn the notice, or propose a settlement. In scenarios where these notices culminate in court cases, failing to identify the actual driver can land you in hot water. While this typically pertains to penalty charge notices, you should always keep the firm informed about the offender. After all, they should be the ones covering the charge. If you've been threatened with court action, or maybe you still have more questions, then you might want to speak to online solicitors JustAnswer. They offer a £5 trial and you can ask them anything you want to know in the online chat. I'll leave a link below this video for you.